Hi, and welcome to Waverley Boorman Lawyers. Today, we are going to look at drink driving offences in New South Wales. Hi, and welcome to Waverley Boorman Lawyers. My name is Josh Boorman. I'm a drink driving solicitor in Sydney. Basically, today I want to talk to you about a low range drink driving offence that we appeared on in Waverley Local Court. And then we actually appealed the decision in that lower court to the District Court in Sydney. So basically, two stages to this matter. It first appeared at Waverley Local Court, and basically this matter involved a low-range drink driving offence. Our client works in a restaurant. He had consumed 2 glasses of wine throughout the evening, one with his dinner, and then another glass of wine as they were packing up the restaurant just before he left to drive home. He was driving home. He was pulled over for the purpose of a stationary random breath test, and he recorded a positive reading at 0.054. So being an unrestricted driver, his legal limit was 0.050, so he was just over that legal limit. And if he had have given it another 20 to 30 minutes, he probably would have been under the legal threshold, but that wasn't the case here. He drove home, he recorded a positive blood alcohol reading, and subsequently charged with low-range PCA. Now, in relation to the actual offence and driving, we impressed upon the court that there were no significant aggravating features involved. He was the sole occupant of the vehicle, he wasn't speeding, he wasn't driving erratically, he was pulled over just for a normal stationary random breath test. And because of the time of night, it was just after midnight, there was minimal traffic on the road, there were no pedestrians around. So we submitted all of these features in relation to our client's offence or incident, reduce the risk of injury or accident or harm to others within the community. He was absolutely cooperative and compliant with police when pulled over, open and honest about the 2 drinks that he had, and certainly in relation to this matter, we entered an early plea of guilty at the first available opportunity, which always seeks some sort of discount when the matter comes before the court. In relation to my client, he's 57 years of age. He has been through a very tough time over the last 12 months with the loss of his wife due to cancer. He's become a single parent, and obviously he's taken on some quite large burdens in recent times due to the loss of his wife and that heartbreak. He's now solely responsible for his young son and needs to provide for him. So basically his job at the restaurant where he works is extremely important to him. And what we did want to impress upon the court was the fact that because he does work quite late hours, getting home after work it's next to impossible with public transport. Either it's inefficient or it's not running. And he's not on a huge wage each week, so spending money on expensive taxis 6 nights a week just to get home would significantly affect his ability to earn income and provide for him and his son. So we did stress to the court that if he was to lose his licence, he did face this hardship. The other thing that we were able to provide to the court was a statement from his employer, basically saying it wasn't just the issue of him having trouble in getting home in those late hours of the night, but also that before the restaurant starts, he has duties to go and pick up food and supplies for the kitchen and prep the kitchen for the night ahead. So he did have a very inherent need to maintain his driver's license in order to carry out his duties and also to get home of an evening. So a driver's license was a very, very important part of him being able to continue with his employment and earn an income. And we did stress this upon the court, but the one thing that the court did have to balance up was that he had some very strong subjective features in relation to his personal circumstance and his employment. He also had some relatively strong circumstances in relation to objective features, the way the matter came about. There was no aggravating features involved. But the court did see that he did have a traffic record there some 16 years ago. He had been charged with a middle-range drink drive offence. And whilst we did explain to the court that this was during a time of quite significant distress in his life, the court did take it upon itself to not provide our client with the leniency that we were after, due to the fact that he should have already learned his lesson some 16 years ago. And subsequently, they disqualified our client for 3 months. That was the minimum period, reduced down from a 6-month period. They gave him a $500 fine, and he was convicted of this low-range drink driving offence. That was once we received those penalties, we were at the crossroads. That was the penalty we received from the local court at Waverley. Our client was understood he had done the wrong thing, but he was extremely concerned about the fact that he would lose his job and be unable to earn an income to provide for his son and himself. So there was the option there to file an appeal of this sentence and have this appeal heard at a higher court, the district court in Sydney. And that's exactly what our instructions were. Our client instructed us to put this appeal on, and we had the matter set down for an appeal date in the District Court Downing Centre in Sydney, which was heard just on Monday, just gone, late in September 2015. So basically, the issues were pretty much the same in relation to how the incident came about and the strong subjective features in relation to our client. We did have some very, very strong character references for our client, which were already on file. They were tendered at the local court. But we did want to impress upon the court how important it was for our client and the devastating consequences that will come if our client is unable to work due to the fact of a lost licence. So the court once again was put in a position where it had to weigh up the fact that he had a traffic record there. He did have a middle range PCA offence some 16 years ago, but it also had to balance out the fact that he did have an inherent need to maintain a driver's licence in order to continue working. And we were able to once again put those strong submissions forward to the judge in the district court, who was at one point very 50-50 whether he would actually issue our client with a Section 10, which basically meant he could keep his licence, or whether he would leave the penalties in place from the lower court. Because certainly the penalties that he received from the lower court, they were a reduction down from the automatic period of 6 months to 3 months, and those penalties were very much well within range for a drink driving offence of this nature. However, we were happy that the judge was able to take and give probably a little bit more consideration to our client's employment situation and his position as a father and his need to be able to drive to continue to earn an income. And subsequently, he upheld the appeal. He issued our client with what's called a Section 10 and gave him a 2-year good behaviour bond. So ultimately what that meant is the court accepted our client's plea of guilty, but he was not convicted. His licence was not disqualified. He was able to continue driving, which was the big win and the big result that we were after. And he didn't receive a fine for this offence. He was put on a 2-year good behaviour bond under Section 10, which basically means that if he breaks the law again for any sort of offence within the next 2 years, then the court can certainly revoke that good behaviour bond and re-sentence him on this offence, on this low-range drink driving offence, and whatever other offence that would be before the court in breach of the good behaviour bond. So overall, it was a very, very good result that we got for our client. We were happy. We did have to put in the hard yards. We did have to put an appeal on and take it to the next level. And everyone out there should know, if you do receive some penalties in the local court, which you think were a little bit severe or harsh for your circumstance, or you feel very strongly about the need to appeal those sentences given to you in the local court, there always is that option there to appeal that result to a higher court in the district court, and that's exactly what we did, and we came away with a good result today. So guys, this is just another low-range drink driving matter that we represented our client on, initially at Waverley Local Court, and then this week it was set down in the district court in Sydney Downing Centre. if you found yourself in a situation, an unfortunate situation where you've been involved in some sort of drink driving, alcohol or drug related offence, please feel free that you can give me a call and have a chat with me on 9283 8622. I'm happy to have a chat to you about your matter and your situation, what you can expect, and issues surrounding the offence you may have. Alternatively, jump onto our website, beasleyboorman.com.au. There's plenty of information there about laws, penalties, blog posts, issues surrounding drink driving and drug driving and other criminal offences. We do service a whole range of traffic offences in New South Wales, and certainly you can make yourself more aware of the situation you may find yourself in. But by all means, if you want to give me a call for a free first telephone consultation, I'm happy to have a chat with you, and our number is 02 9283 8622. Thanks for tuning in, guys.